erroneous the order granted on the basis that it was granted in the absence of those submissions. Indeed, it is a tried principle of the law of rescission that the existence or non-existence of a defense on the merits is an irrelevant consideration, and if subsequently disclosed, cannot transform a validly obtained judgment into an erroneous one. Mr. Zuma had multiple opportunities to bring these arguments to the attention of the court. That he opted not to cannot mean that the court committed an error in granting the order. In any event, the majority finds that the ground advanced by Mr. Zuma as rescindable errors are devoid of merit and, in fact, are issues that the Constitutional Court has already disposed of when it dealt with contempt proceedings and thus have no place in a rescission application. As an alternative to Rule 42, Mr. Zuma pleaded rescission on the basis of the common law, in terms of which an applicant is required to prove that there is sufficient or good cause to warrant rescission. It is well established in our jurisprudence that to prove sufficient cause for rescission, an applicant must furnish a reasonable and satisfactory explanation for his or her default. He or she must then show that on the merits, he or she has a bona fide defense which carries some prospect of success. It is imperative that I emphasize that both of these requirements must be met. What this means is that Mr. Zuma must establish that he had a reasonable and satisfactory explanation for his failure to oppose the contempt proceedings, and in addition that he has a bona fide case that carries some prospects of success. The Constitutional Court concludes that Mr. Zuma has failed to meet these requirements. Not only does his application lack prospects, all of his submissions having already been disposed of, he has failed to provide a plausible and acceptable explanation for his default. That he may have taken issue with the profile of the Commission is of no moment, and allegations of bias in respect of its chairperson cannot justify his absence from proceedings in the Constitutional Court. To his peril, Mr. Zuma declined to participate in the contempt proceedings and disdainfully dismissed a further opportunity when invited to do so. He only attempts to justify his absence now that the shoe pinches. He cannot hope to succeed on the merits for, as outlined already, an unsatisfactory explanation remains so, whatever the prospects of success on the merits. This is not the end of the story. Mr. Zuma submitted that if he failed to establish the requirements for rescission under Rule 42 or the common law, then the Constitutional Court should nevertheless reconsider its order on the basis that the miserable litigant impugns the constitutionality of the order. The position Mr. Zuma advocates necessarily involves the broadening of grounds for rescission. So the court is seized with the question whether it should indeed expand the grounds for rescission. The majority finds that far from inviting courts to expand the scope of rescission, our jurisprudence suggests we must do the opposite. The legislature has deliberately carved out exceptionally narrow grounds of rescission because the very notion of rescinding a court order is an affront to the rule that orders, especially those of the apex court, are final. This, the Constitutional Court emphasizes, is important because if orders of court are too readily set aside, the administration of justice would be compromised by chaos. Despite Mr. Zuma's creative attempts to have the order set aside, the majority of the Constitutional Court finds that the qualification Rule 29 of such modifications as are necessary provides no panacea to this ill-fated application for rescission. If the Constitutional Court were to adopt a generous approach in construing Mr. Zuma's case, it might be open to it to reconsider its order if it would be in the interest of justice to do so. Because the second judgment finds that this is what ought to be done in these circumstances, it is necessary to pronounce on this. The majority finds that although there may be circumstances in which the interest of justice require rescission, those circumstances must be wholly exceptional to justify a departure from the res judicata doctrine. And there is nothing in Mr. Zuma's case that can be construed as truly exceptional to the extent that the court should depart from the underlying principle and ordinary tenets of the rule of law. Far from causing a grave injustice if the court refuses to consider its order, the administration of justice would be brought into dispute if this court were to reconsider it. Having established that the interests of justice do not compel the majority to expound the grounds of rescission or reconsider the application, the majority emphasizes that the interest of justice requires the Constitutional Court to protect the principle of finality in litigation. It is precisely to protect this principle that orders of the Constitutional Court are immune from appeal and that the doctrine of functus officio binds courts. Of course, Rule 42 creates an exception to that doctrine, but only in narrow circumstances. The majority finds that the court is functus officio in respect of the grounds advanced by Mr. Zuma, and that it would not be in the interest of justice to relax this doctrine or expand the grounds upon which a rescission can be sought. To do so would be to dismember the rule of law. Finality and legal certainty are the linchpins of the interest of justice inquiry, and the uncertainty that has shrouded this application has already done untold damage to the rule of law and those principles that underlie it. In navigating the interest of justice inquiry, the majority finds that Mr. Zuma's conduct is also relevant. The Commission and HSF argued that he preempted or waived his right to bring this application as his conduct indicated that he was not in the least concerned with what decision the court might reach. The principle that underlies the doctrine of preemption is that no person can be allowed to take up two positions inconsistent with one another, to blow hot or cold, or to appropriate or reprobate. While it is not wholly fair to state that Mr. Zuma acquiesced in the judgment by acting in a manner synonymous with an intention to abide by it, after all, he did launch this application. The majority finds that the underlying principles of preemption resonate. Mr. Zuma's behavior, albeit made manifest before the judgment and order were handed down, pointed indubitably to the conclusion that he had resigned himself to any decision that the court might make. With this in mind, to entertain Mr. Zuma's application in these circumstances would be to permit him to blow hot or cold. It would fly in the face of the interest of justice for a party to be allowed to willfully refuse to participate in litigation and then expect the opportunity to reopen the case when it suits them. It is simply not in the interest of justice to tolerate this manner of litigious vacillation. The majority of the Constitutional Court is also not persuaded by the reasoning of the second judgment, which I shall come to momentarily. The second judgment concludes that the impugned order and the effect of authorizing Mr. Zuma's detention without a trial in contravention of Section 12, subsection 1b of the Constitution, and that the procedure leading up to his conviction and sentencing breached his rights guaranteed by Section 35 and Section 35, subsection 3 of the Constitution. The second judgment contends that the determination of these issues depends on the proper interpretation of the Constitution, which requires recourse to international law. Particular emphasis is placed on Article 9 and 14, subsection 5 of the International Covenant on Civil and Political Rights, in brackets called ICCPR. Article 9 guarantees the right to liberty and security of the person, including the right not to be detained unlawfully, whilst Article 14, subsection 5 provides for the right to have one's conviction and sentence reviewed by a higher tribunal. The second judgment maintains that the judgment and order are not only unconstitutional, but are not compliant with international law, which renders the order rescindable. The majority accepts that it is incontrovertible that the Constitutional Court, like all South African courts, is constitutionally enjoined by Section 39, subsection 1b of the Constitution to consider international law when interpreting the rights in the Bill of Rights. This is an interpretive injunction, however, and does not oblige any South African court to prefer a position taken in international law, as the second judgment suggests. The majority emphasizes that the status of international law must not be mischaracterized. Furthermore, the majority disputes the relevance of the ICCPR to a rescission application launched in a South African court. Firstly, it must be emphasized that in a dualist legal system like South Africa's, international treaties do not create rights and obligations capable of being enforced domestically unless they are incorporated by an act of parliament. The ICCPR has not been incorporated and therefore only binds South Africa at international level. Its provisions cannot be invoked by litigants in our domestic courts. Thus, any alleged incompatibility with its provision simply cannot constitute grounds for rescission or reconsideration in a domestic court, including the Constitutional Court. Finally, the majority emphasizes that the doctrine of subsidiarity, crystallized as a structural principle of international law, recognizes the need to defer to domestic approaches to implementing international law. Accordingly, the majority finds that the degree of reliance placed on the ICCPR by the second judgment is misguided. This is a relatively straightforward matter. Mr. Zuma has met neither the requirements of a rescission in terms of Rule 42, subsection 1A, nor the requirements of one as governed by the common law. Mr. Zuma is seeking to reopen the merits of the contempt proceedings, which have been disposed of already. And it is contrary to interest of justice to recall that matter to life by expanding the grounds of rescission and reconsidering the judgment and order handed down on 29 June 2021. It is unfortunate, to say the very least, that Mr. Zuma failed to bring the submissions with which he now arms himself to the Constitutional Court before we reach this point. For all that can be said is that the predicament in which he now finds himself is not the making of the courts, nor does the solution lie with the courts. The hands of the Constitutional Court are bound, and Mr. Zuma himself bound them. It must, of course, be emphasized that rescission is an avenue of legal recourse, remains open, but only to those who advance meritorious and bona fide applications and who have not, at every turn of the page, sought to abuse judicial process. On a conspectus of all of the above, the conclusion of the majority of the Constitutional Court reaches is that this application falls to be dismissed with cost. The second judgment, penned by Jafta J, with Jaron J concurring, finds that the issue for determination is whether the motion procedure followed when Mr. Zuma was convicted and sentenced complied with Section 12, subsection 1b, which guarantees the right not to be detained without a trial. The second judgment interprets this section and concludes that it requires a trial to be held before an individual may be detained. Since here there was no trial, the second judgment concludes that the detention was invalid as it was inconsistent with Section 12, subsection 1b of the Constitution, unless it constituted a reasonable and justifiable limitation. Having undertaken the justification analysis, the second judgment concludes that the limitation was not justifiable. Accordingly, the second judgment holds that the detention was unconstitutional and invalid. The second judgment, with reference to Section 172(1) of the Constitution, points out that the Constitutional Court is obliged to declare the detention invalid and set it aside. It points out that the invalidity of the order flowed from its being inconsistent with the Constitution. Theron J concurs in Jafta J's judgment, subject to the qualification that there is no need to craft a separate ground for intervention. Theron J holds instead that on the basis of Mulaudzi versus S, an order of the Constitutional Court can be reconsidered in exceptional circumstances and where the interest of justice cries out for intervention. Theron J agrees with Jafta J that the order made by the majority in the contempt proceedings was made pursuant to an unconstitutional procedure. Theron J holds that the Mulaudzi test is thus satisfied because Mr. Zuma was incarcerated on the basis of an unconstitutional procedure and importantly without a right of appeal, meaning that his case is truly exceptional and cries out for intervention, failing which he will be visited with substantial hardship and injustice. In the result, the majority of the Constitutional Court makes the following order. 1, direct access is granted. 2, counsel for the advancement of the South African Constitution and democracy in action are admitted as amici curiae. 3, the application for rescission is dismissed. 4, Mr. Jacob Gedleyihlekisa Zuma is ordered to pay the cost of the Secretary of the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state, and Raymond Mnyamezeli Zondo, NO, including the cost of 2 counsel. I hand down the judgment.
Please rise.